pursuant to an extradition warrant that was served on you for alleged violation of pretrial release. That was signed by Judge Wooten in Orange County, Florida. And as to both counts, it indicates that the bond is set at none. Anything further, counsel?
Yes, Judge. The case in Escambia County, this is where his parents live. He currently, because of these charges in Orange County, lost his employment and thereafter lost his apartment. So he moved back into his parents' home in Escambia County in Pensacola. These charges in Pensacola have now been dropped. He was arrested on October 6th, and the charges were dropped, no info 12 days later, and I verified that with the state attorney, showed them the docket that the charges have been dropped up there. And so I understand that he violated his pretrial release because of the new law violation, but without income, without a place to stay, and his father's driving down. It's a 7-hour drive. He's driving down right now to try to bond him out. We asked, and their financial situation is very poor right now. So we just asked for the most reasonable bond that you could possibly do, and that he be allowed to return to Escambia County. There's no contact provision out there because the case has been dropped. It involved a suicide attempt by the defendant. They attempted to Baker Act him, and his situation has caused him to fall into a depression. His parents want him back with them in the home badly. The dad wants to bond him out and get him back in the house.
Do we have some documentation to show that it's been dropped, or does the
I
state
do.
agree with that?
Yeah, I researched the docket in Escambia County, and I showed the state attorney, and I have it on my phone if you want to see it.
Yes, Your Honor. The state has seen that the charges have been dropped and that all associated warrants and bond requirements have been removed per the docket from Escambia County.
All right, so with that, the state agrees, has no objection to the court.
The state has no objection to the court setting a
him on
reasonable
his original
bond.
bond?
He was pretrial released originally because of his lack of criminal history, so whatever reasonable bond you want to set, Judge.
The state agrees.
All right, thank you. We'll have that notated in the minutes so that it'll reflect that the parties stipulate that the underlying, or the alleged new offense has been filed?
No infoed,
No info? Okay.
correct.
And therefore, the court at this time will set the bond as to count one will be pretrial release. As to count two, the court will set the bond
He doesn't qualify for PTR on a charge. This charge
as to
doesn't.
battery.
Because it's a violation of a condition of PTR. We don't qualify them for those.
I'm not finding him as a violation of PTR. I just indicated that he's not putting him on an original bond. But if you say so, I'm just confused because I'm not finding him for that.
Right, but they come in on that charge and
Okay.
we don't qualify or interview or
Okay,
do anything for those.
okay, all right, thank you. So at this time, the court will set the bond as to count one at $250. The bond as to count two will be set at $1,000. He's to have no contact with the alleged victims in the case. They'll return to the scene of the offense.
To be clear, we're talking about the alleged victim in the Orange County case, correct? Correct. Okay. Thank you, Judge. We appreciate your time this morning.
Thank you.
Thank you.
Thank you. With the name. Good luck.
Well, will you clearly state in there that they've indicated that there's been no file, no info on the Escambia?
Good afternoon.
I think you got it.
Gerard Aquino Castro.
Good afternoon.
Good afternoon. How are you this morning?
Good, how about you?
Good, thank you for asking. You're before the court at this time after being picked up on a warrant for an alleged violation of probation in case 2021 MM8307. The bond is set at none, therefore you'll need to appear before the judge to sign to that case to get a bond set. Thank you.
I believe he has another case, Your Honor.
was already seen on that other case.
Oh, he was? Okay, sorry.
What'd you say?
It's okay.
Gilbert Acosta. Thank you.
Hold on, may I stay my-
You have no bond, no violation of probation.
Are you Gilbert Acosta?
Yes, ma'am.
Are you before the court at this time for being charged with the offense of robbery armed with a deadly weapon? Your bond is set at none as to that count. As to count 2, you are charged with aggravated assault with a deadly weapon, domestic violence. Your bond is set at $2,500. As to count 3, you're charged with the offense of use of a firearm or weapon in the commission of a felony. Your bond is set at $4,000. You're to have no contact with the alleged victim in the case. You're not to possess any firearms or weapons.
Your Honor, I do think you do have a witness
Oh,
out.
I'm sorry, ma'am. Your name?
My name is Megan Clark.
I need you to speak up so I can hear you.
Hi, my name is Megan Clark.
If you'll raise your right hand to be placed under oath, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You may put your hand down. Would you like to say something to the court?
Yes. I would like to ask if he can have a bond for the first charge that you said he will not have a bond for. I also would like to drop the charges, and I would like to have contact with him.
I'm not going to grant a bond for the first charge. And also, if you'd like to drop the charges, you need to speak with the state attorney's office to indicate to them that you'd like to sign a declination of prosecution. And I'm not going to allow any type of contact at this time. You can go before the trial judge who's assigned to the case, and then that's something that the judge can consider at that time. Okay? Yes,
Your
State.
Honor, will you repeat the bond amount for the third count, please?
Third count is $4,000.
Thank you.
You're welcome. All right, thank you all. Gregory Barnes, is that your name, sir? Yes. All right, so you're before the court at this time for the charge of child abuse, count 1, and that bond is set at $1,000. Count 2, your charge is domestic violence assault, setting the bond at $500. Count 3, your charge is domestic violence battery, and I'm setting your bond at $500. Is there a victim on this case?
Oh, Your Honor.
All right, thank you. You, sir, you are not to have any contact with the victim until further order of the court. Janice Crumpton. Ms. Crumpton, you're before the court at this time for the charge of aggravated battery with a weapon. Your bond will be set at $5,000. You're not to have any contact with the alleged victim in the case, and you're not to possess any firearms or weapons. Thank you. Shannon Sullivan.
Your Honor, I do apologize. She was asking a question. 1 second, Your Honor, I apologize. Your Honor, she's inquiring about ROR in regards to this case, but seeing that of the type of offense, I'm not sure if she qualifies, but she would like to see if she can get released ROR.
I'm not granting ROR at this time.
Okay.
Shannon Sullivan. Good morning, sir. You're before the court at this time after being charged with 4 offenses. Count 1, you're charged with false imprisonment, domestic violence. Your bond is set at $3,000. To count 2, charges tampering with the witness to hinder communication to a law enforcement officer. The bond is set at $1,000. As to count 3, you're charged with battery and committed domestic battery by strangulation. Bond and that charge is $500. And as to count 4, your charge is criminal mischief greater than $200, less than $1,000. Your bond is set at $150. Is there a victim on this case? All right, thank you. You're not to have any contact with the victim in this matter. You're also ordered, the same address. That's the order of the court. Eddie Watkins?
Refuse, Your Honor.
Refused? Do you waive his appearance?
Yes, Your Honor.
Mr. Watkins is charged in case number 2022 CF 12604 with the offense of burglary of a dwelling. His bond is set at $5,000, as well as count 2, domestic violence stalking. His bond in that matter is set at $500. The court is ordering that he not return to the scene of the offense, and he's to have no contact with the victim in that case. He was out on bond at the time of the alleged offense in case number 2000. Case number 2022 CT 7790. He was released on his own recognizances as to both counts. This is 2 counts, though, right? Okay. As to count 1, the bond will be set at $1,000. As to count 2,
Your Honor, they only filed on 1 count
okay, which count
in
then?
that case.
The-
Let me pull it up, Your Honor.
We don't get all that information. And count 1 is possession of the controlled substance? Yes. All right, thank you. That bond will be set at $1,000. Annabelle Diaz?
Yes, ma'am.
All right, thank you. So you're before the court at this time after being charged with the offense of domestic violence battery. Ma'am, if you'll raise your right hand to be placed under oath, do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. Your name, please?
Bernadette Diaz.
All right, and what is it that you'd like to say?
I wanted to say that I never called the police on him. We never called the cops. Police were called. We were in an argument like any couple. We've been married for 28 years. I am not scared of this man. There is nothing that was done that was out of the ordinary as a regular confrontation between 2 people arguing. So we left. We both left to cool off the situation from the home. And when we came back, it was hours later, and he was arrested at home. They didn't even read him his rights or anything. He was just taken.
All right, thank you. Anything from state or defense?
From defense, Your Honor, we would just like a no hostile contact and that they maintain the same residence.
While the state appreciates the testimony of the victim, there was another witness, victim witness involved in this incident, and the state would be asking for no contact with that victim because that victim did indicate that they wish to press charges. And because this is a case that has a witness, the state will not be dropping any charges at this time.
At this time, thank you, ma'am. Anything further?
That's it. Thank you so much.
All right, thank you.
He does qualify for PTR, Your Honor.
All right, at this time, the court will order that the bond be set at $500. I'm going to order that the the defendant have no hostile contact with the victim, and he may return to the place of residence. But for the record, the affidavit indicates that the law enforcement observed what appeared to be a black eye. So there is sufficient indication that there was some type of altercation going on.
A black eye on who, Your Honor?
I'm making my ruling, ma'am.
Oh, okay. Because
I'm, on you, that's what they're indicating. So if you,
I'm right.
I'm not here to judge that, ma'am, I'm not a jury.
Oh, well, I don't have
I'm
anything on
not
my
here to go
face.
back and forth with you either.
No, Your Honor, I'm just
Okay,
saying.
I'm making my ruling. I heard what you had to say.
Was that PTR?
No, that's $500.
$500, okay, just making sure.
Thank you. He's not to possess any firearms or weapons. Christopher Figueroa.
Yes, ma'am. Good morning.
Good morning, sir. You're before the court at this time for an initial appearance. You've been charged with the offense of domestic violence battery. It indicates that you do not qualify for the public defender's office. Therefore, you will need to seek private counsel in order to represent you in this case. I do not see that there is anyone here to testify on your behalf. I'm going to order that your bond be set at $500. You're not to have any contact with the victim in this matter.
Okay.
Thank you.
Oh.
Elijah Griffin?
Yeah.
You're before the court at this time after being charged with the offense of domestic violence battery. Your bond will be set at $500, and you're not to have any contact with the victim in the case.
Much?
500.
How much is bond?
Angela Hedrick?
And Ms. Hedrick does qualify for PTR, Your Honor.
Good morning, Ms. Hedrick. You're before the court at this time after being charged with battery. You qualify for pretrial release. I'm going to order that you be placed on pretrial release. You do not qualify for the office of the public defender. Therefore, you'll need to retain private counsel to be represented by an attorney. And at this time, I'm going to order that you have no contact with the victim in the case. All right, thank you. Steve Hopper?
Mr. Hopper also qualifies for PTR, Your Honor.
Sir, you're before the court at this time. You are Mr. Steve Harper, correct?
Yes, ma'am.
All right, you're before the court at this time after being charged with the offense of domestic violence battery. There's a victim or a witness that is present within the booth, ma'am. If you'll raise your right hand, please. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. Would you state your name?
My name is Robin Wheeler.
All right, and your relationship to Mr. Hopper?
He's my boyfriend of 20 years.
All right, and what is it that you'd like to say to the court today?
Last night we had a altercation verbally. The cops were called. I did not call. I did not press charges. He didn't touch me. So I don't know why it got pushed to this point.
And what is it that you would like, ma'am?
For the charges to be dropped. I didn't file
I can't drop the
charges.
charges myself, so if that's something you'd like to do, you'd have to speak with the state attorney's office. Is there anything else?
I don't fear him. We have a child together. 20 years, we've never had a problem.
All right, thank you. State any questions?
No, Your Honor, and I have documented that you wish the charges to be dropped.
All right, thank you. Anything from the defense?
Defense would like no hostile contact and that client be released on PTR because he qualifies, and that they maintain the same residence, Your Honor.
Does he qualify for PTR?
He does, yes, Your Honor.
All right, thank you. I'll order that he be released on pretrial release. He'll be able to reside with the victim, no hostile contact pursuant to the request of the victim at this time.
Thank you for being here. Our office will reach out about dropping the charges.
Thank you kindly.
Just let me.
Thank you.
Marquise Jordan? All right, good morning, sir. You're before the court at this time for an initial appearance. You've been charged with the offense of battery, as well as the offense of resisting an officer. without violence. As to count one, your bond is set at $500. As to count two, the court orders that your bond be set at $500 as well. I have here that he was out on bond in case number 2022 CF 134.
That's correct, Your Honor. They filed on one count, the first count of possession of a firearm by a person found to have committed a delinquent act.
All right, at this time, I revoke the bond and order that the bond be set at $5,000 at this time.
Your
To
Honor,
continue not to have possession of firearm or ammunition.
Your Honor, can I speak to Clyde for 1 second? He has a question. Thank you.
No contact with the victim. I thought I said so.
Your Honor, client would like to know if he's able to be ROR'd in regards to the battery case and the resisting officer without violence case. The new cases that you just set the $500 bonds for, Your Honor.
No. Anything else?
No, that is all, Your Honor.
I'm not sure if you heard me. He used to have no contact with the victim.
No contact with the victim, okay.
Thank you.
We have bond in all your cases.
Dominic Kendrick.
And Mr. Kendrick does qualify for PTR.
All right, thank you. Sir, you're before the court at this time for the offense of domestic violence battery, and I have a witness in the booth. Sir, if you'll raise your right hand, do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, thank you. You may put your hand down. Would you please state your full name?
Jermaine Omar Kendrick.
I can't hear you.
Jermaine Omar Kendrick.
Thank you. And would you please tell me your relationship in this matter?
That's my little brother.
Okay, and what is it that you'd like the court to know?
I like the charges dropped and he can come home.
Charges dropped. Okay, all right, thank you. Are you afraid of the defendant?
No, I'm not.
All right. Anything from the state or the defense for this witness?
Our office will be in contact about dropping the charges.
Okay.
I've notated that and I have nothing further.
All right, anything from the defense?
Your Honor, it's a PC challenge. The victim indicated that client swung on him. I didn't see where he said it connected, and then the altercation ensued. So I'll say there's no probable cause for a battery because swung on him. He didn't say whether or not the fist connected to him, so.
I hit my own head. I fell into the wall. It's on camera. We have camera.
All right, I do find that there's sufficient probable cause for the offense. Does he qualify?
Yeah, yes, Your Honor, he does.
All right. I'm going to order that he be released on pretrial release at this time. He may he may have contact with the victim, as the victim has indicated that he has no fear and is requesting that the charges be dropped. All right,
Is
thank
it no
you.
hostile contact, Your Honor, or?
No hostile contact.
Thank you for coming. We'll be in touch.
Ralph Atkins. Good morning, sir. You're before the court at this time for several cases. In case number 2022 CF 12624, you've been charged with, you were picked up on an Orange County warrant for failure to appear for I'm sorry. In case number 2022 CF 12624, you've been charged with the offense of petty theft with 2 prior convictions. Does this gentleman qualify for pretrial release?
No, Your Honor, he does not.
All right. As to that count, sir, I'm going to order that your bond be set at $150. In case number 2022 CF 4454, you were picked up on a warrant for your failure to appear in that case. Your bond in that case has been set at $2,000. And that was because you failed to appear for an arraignment on September 15th of this year. In case 2022 CF 8188, a warrant was issued, or CAPIS was issued for your pickup, and you've been picked on that, up on that CAPIS because you failed to appear for arraignment on September 2nd, 2022. And their bond has now been set at $1,000 in that case. Case number 2022 CF 7548. You were picked up on a warrant from Orange County for your failure to appear for pretrial on December 6, 2022. Your bond now is set at $1,000 as to that case. Please keep in touch with the Public Defender's Office, sir, so you'll know when you go to court and so that the capias will not be issued for you anymore. Donald Anderson.
Bonded, Your Honor.
Thank you. Charlesworth Andrew.
Also bonded.
Daldell Antonio.
Yes, ma'am.
Good morning, sir. You're before the court at this time after being charged with 4 offenses. The Public Defender's Office is not being appointed because it indicates by the clerk that you do not qualify. Therefore, you'll need to seek private counsel to represent you if you wish to have counsel. The charges filed against you, it's possession of cocaine. Your bond is set at $1,000 as to that offense. Possession of MDMA or ecstasy, your bond is set at $1,000 as to that offense. Possession of methamphetamine, another third count, and your bond is set at $100. And possession of drug paraphernalia, your bond is set at $1,000. You're not to possess any controlled substances while on bond. That's all we have.
And Your Honor, he is out on bond as well. It was found before court on a 2022 CF 012540 AO. It's for possession of cocaine and possession of cannabis less than 20 grams.
We have the bond that's been set. I don't have it, one of the
It
orange
was,
sheets on top.
it was 1,000 and 250. Count 1 was 1,000, count 2 was 250.
All right, I'm going to revoke the bond in that case. Count 1 will be 2,000, count 2 will be 500. Thank you. Jacob Ayers? Are you, no?
We don't have that name on the docket, Your Honor.
All right, for the record, the court is called Jacob Ayers, inmate number 2202540. And,
Looks like they bonded out, Your Honor.
okay, and that person is bonded. Kern Blunt, is that you, sir?
Yes, ma'am.
All right, you're before the court this morning, after being charged with the offense of possession of MDMA or ecstasy. Your bond is being set at $1,000. While after, you picked up this charge while you were out on bond in case number 2022 CF 9872. Your bond in that case was set at $2,500. I am revoking that bond, and now your bond will be set at $5,000 with all the original conditions that were imposed. Thank you.
Your Honor, one moment, please. I apologize. He has a question.
What is that?
I'm going to ask the judge. Yes,
Okay, okay, I'll ask.
okay.
Louise Bertugno? Is that your name, ma'am?
Yes, ma'am. Louise Portugno.
Okay, thank you.
You're welcome.
You're before the court at this time for the offense of prostitution with as your third subsequent violation, or at least third, because you've been previously charged with that.
I've actually been doing really good, ma'am. I was hit by a car in
Well,
August.
hold on, I don't know if your attorney wants you to say anything, okay? All right, that's the offense that you've been charged with. And your bond as to that count is set at $1,000. You've also been charged with the offense of possession of ketamine, and that charge has a bond of $150. You were out on bond at the time that you picked up this offense in case these,
Sorry.
Cause she,
She's on pretrial diversion, Your Honor.
thank you, I was gonna ask you because it doesn't indicate.
Yeah.
Well, it does at the top, I'm sorry.
Yeah, she was ROR'd originally and then referred to PTD.
so she's still currently doing PTD.
Yes.
So Your Honor, defense is asking because she's currently enrolled in a PTD program that she's not revoked or anything, her RR is not revoked in regards to the out on bond case or out on RR case.
Picked up the same offense while she was doing that. Say you stood up, I'm sorry.
Your Honor, PTD will make a determination of whether or not they're going to allow her to continue. We have no objection to you taking no action on the PTD.
Okay. we'll leave it up to the
Release.
state.
Since she has a bond in the new charge, that's sufficient.
Your Honor, client would like to see, we do understand that she did pick up the same offense, Your Honor. However, client would like to see if she can be released RR in regards to the two new cases, Your Honor. We apologize.
Not as to the two new cases. I haven't done anything as to the case in which she's currently participating in PTD, but I'm
Okay.
going to leave the bond as to the current case.
I do apologize, Your Honor. I'm speaking to her for 1 second.
No problem.
Your Honor, we understand that bond was set on count one. Is it possible if you can reduce the bond to $150, something more reasonable that she can be able to afford?
As to the first one, I'll reduce it to $500.
Okay.
Bobby Bowman,
He's medical, Your Honor.
We will waive his appearance, Your Honor.
all right, at this time, the court will set the bond as to the charge of aggravated battery with a deadly weapon to $3,500. The defendant is to have no contact with the victim in the case and not to possess any firearms or weapons. Juan Castro? Good morning. Sir, you've been charged with the offense of fleeing or attempting to elude a law enforcement officer with sirens and lights activated. At this time, the court is setting your bond as to that count at $1,500. As to count two, you've been charged with possession of a concealed weapon or firearm by a convicted felon. Your bond as to that will be set at $1,000. As to count three, you're charged with driving while license revoked as a habitual offender. Your bond is set at $150. You're not to possess any firearms or weapons in this matter. Otis Davis?
Yes, ma'am.
Good morning, sir. You're before the court at this time after being charged with the offense of grand theft third degree of greater than $750 and less than $5,000. Your bond as to that count is set at $1,000. As to count two, you're charged with possession of burglary tools. Bond as that count is set at $100. As to count three, you're charged with resisting officer without violence. Your bond as to that count is set at $100. You're not to return, sorry. You're also before the court after being released on bond in case number 2022 CF 2567. This is the Osceola County case. Do we know the bonds in that matter?
I'll try to get on the Osceola clerk site quickly, Your Honor.
Thanks.
Looks like it was. I can see the bond amounts, I can't see what count they go to. But it looks like there were four $500 bonds, $1,000 bond. And there are 6 counts, but I don't see the other counts bond amount on their website.
So I'm going to currently revoke the bonds that were currently issued and the,
Revoke 'em?
yes. You picked up new charges while out on bond. So pursuant to the administrative order, I'm going to revoke those bonds. And I'm going to order that as to each of the bonds that were given a monetary amount pursuant to the administrative order, they will be doubled. If he has released on recognizance as to any other counts, those shall remain. Thank you. Montana Felix.
Your Honor, I apologize. I'm speaking to Clyde for one moment, please.
Sure. Sir, are you Montana Felix?
Yes, ma'am.
Are you before the court at this time in case number 2022 CF 12651? You've been charged with trafficking in cocaine greater than 28 grams with a firearm. Your bond is to that count is set at $100,000. You're also charged with possession of a firearm or ammunition by a convicted felon. Your bond is to that count will be set at $1,500. You're charged in count 3 with grand theft, 3rd degree of firearm. Your bond is set at $1,000. And you're also charged in count 4 with carrying a concealed firearm. And the bond as to that matter will be set at $500. You're not to possess any firearms or weapons while, as a condition of this bond, as well as you're not to possess any controlled substances. There's also a capias that has been issued for your arrest in 2022, CF 1996, out of Orange County, Florida. I'm sorry, that's incorrect number. Well, I got 2 case numbers. You were out on bond in case number 2022. Yes, that's the correct number, CF 1996. And it was for your failure to appear for case management conference on July 14, 2022. So your bond at this time has been revoked in that matter and is set at 0. You'll need to go before the trial judge to get another bond in that case. Nancy Fillmore. Good morning, sir. You're before the court at this time for initial appearance. You've been charged with the offense of trespass. Does he qualify for pretrial release?
He does not, Your Honor.
All right, at this time, your bond will be set at $250. You're not to return to the scene of the offense. You're also before the court in case number 2022 CF 3843. Capias was issued out of Orange County, Florida in that case for your failure to appear. You failed to appear for a status hearing on on October 24th, 2022. Your bond in that matter has been revoked and has now been established in the amount of $1,000. Thank you. Kenneth Forsett. Sir, you Kenneth Forsett?
Yes.
All right, sir, you're before the court at this time for an initial appearance, and you have been charged with the offense of possession of a concealed weapon by a convicted felon. Your bond as to that matter is set at $4,000. You've also been charged with possession of drug paraphernalia. I'm going to order that you have a bond of ROR as to that count. You're not to possess any firearms or weapons while on bond. And if you're a convicted felon, that would be offensive as well.
Your Honor, I apologize. Client's asking a question. One moment, please. Your Honor, we do understand that bond for count one was set at $4,000. At this time, we're asking if it could be lowered to $1,000 because of the weapon that was found in the vehicle was like a pocket knife, and it wasn't like an egregious weapon such like such as a gun.
Oh, okay. Yes, I'll set the bond. You want to be heard, State? Would you like to be heard?
Oh, no, I was gonna say I don't object to lowering the bond.
Okay, great, thank you. All right, yes, I'll grant that request. I'll lower the bond to $1,500.
Yes.
Jermaine Fortner,
In the hospital, Your Honor.
Defense will waive, Your Honor.
And state would like to be heard.
yes.
The state is asking that we're moving to revoke the bond in 22 CF 12244 and 2022 CF 12279 for the new law violations, and ask that he be held on no bond for his charges that appear before the court today.
Anything from the defense?
The defense will only say that since no information has been found in the cases that he's out on bond for, that no action is taken by the court.
I actually was inclined to do the same thing as the state has requested in light of the charges that have been filed and the offenses for which he's already currently on bond. These are very
Understood.
violent offenses, and therefore, at this time, with the new offense of attempted first-degree murder with a firearm discharge, the court is going to set the bond at none. As to count two, possession of a firearm or ammunition by a convicted felon, the bond will be set, I will set a bond as to that count at $7,500. As to the cases in which he is currently out on bond, 2022 CF 12244 and case number 2022 CF 12279 AO, the court revokes the bonds in both cases and will be set at none, and he'll need to go before the trial court to have any bond set. Jeremy Harris?
Yes, ma'am.
Is that you, sir? Good morning. You are before the court at this time for the charge of possession of tetrahydrocannabinoids, and your bond is set at $2,500 as to get that count. As to count two, possession of drug paraphernalia, I'm setting your bond at $150. As to count three, possession of cannabis less than 20 grams, setting your bond at $100. You're not to possess any controlled substances while out on bond.
So what
Without a
does that
valid
mean, ma'am?
prescription. Sorry?
Does that mean I can bail out?
I set your bonds, yes.
Thank you. I also had a question.
You want to ask your attorney, not me? Ask her.
Your Honor, question in regards to the charges that was found. We're saying that there's no PC for the, cannot pronounce it, the cannabis. Is that short for, that's THC, which is short for cannabis. So we're saying there's no probable cause for the THC?
And what's your argument? What's the basis for your argument?
Because he's being charged twice. Because he was charged for possession of cannabis, charged for possession of drug paraphernalia, and also charged for THC, which is the cannabis.
What is your response, counsel?
Just one moment. The charge for the tetrahydrocannabinols is actually pertaining to the gummies that he was found in possession of. So they placed THC in the candy, and then you are able to consume the drug in that form. And then there was also cannabis in its naturally occurring state. So we would contend that there is probable cause for the first charge.
Court finds probable cause.
Okay.
All right, thank you. You're welcome. Ray Harrison. Morning, sir. You were charged with the offense of sale and delivery of methamphetamine. At this time, your bond is set at $2,500. You're not to have possession of any controlled substances unless prescribed by a physician. Gordon Hostler. So you're before the court at this time after being charged with the offense of driving under the influence. And as to that count, your bond is set at $2,500. And that is because it is your third violation within a 10-year period, so your bond is higher than usual. As well as count 2, you have driving while license suspended or revoked. The bond is to that matter would be set at $1,000. Right, thank you. Aaron Israel.
Bond, Your Honor.
Keith Jarrell. So you're before the court at this time after being charged with the offense of possession of MDA. Your bond is set at $1,000. You're not to possess any controlled substances without a valid prescription.
Your Honor, in regards to this case, if client can be released RR, he does just have one criminal history that I can see, a misdemeanor, and just one failure to appear back in April.
What is the last thing you said?
One failure to appear, but it was back in April, Your Honor.
April of 2022?
Yes.
Okay. All right, I'm gonna deny that request. Rayson Jace Johnson.
Bond, Your Honor.
Yeah.
Rasheen Jones.
Refused, Your Honor.
Sorry, Your Honor. In regards to this case, we can waive his appearance.
Okay, thank you. In case number 2022 CF 12629, defendant is charged with the offense of battery on a law enforcement officer. Bond is set at $2,500. He's also charged in count 2 with resisting officer with violence. Bond is set at $1,000. And it's count 3, resisting officer without violence. Bond is set at $150. Defendant was out on bond, defendant was released ROR in case number 2022 CF 6313. Yes, two cases. Oh. That's one case. So he does have a second case, in case number 2022 CF 12630. He's been charged in that matter with count 1, possession of a firearm by a convicted felon. His bond is set at $4,000. Count 2, carrying a concealed weapon by a convicted felon. Bond is set at $2,500. Bond is to count 3, possession of ammunition by a convicted felon. Bond is set at $1,000. Count 4, resisting officer with violence. Bond is set at $1,000. Count 5, possession of MDMA and ecstasy. Bond will be set at $500. As to count 6, resisting officer without violence, bond will be set at $150. As to count 7, possession of cannabis less than 20 grams, bond is set at $100. And as to count 8, possession of drug paraphernalia, court sets the bond ROR. In these, there's a pending matter, case number 2022 CF 6313. The defendant's bond, the defendant's release on his own recognizance is revoked. Bond is to count 1, 3, 4, and 5. Will be set at $150. Bond is to count 2, will be set at $1,000. Kirsty Jordan. Ms. Jordan, you're before the court at this time after being picked up on a capias that was issued in an Orange County case, 2022 CF 4929, after you failed to appear for an arraignment on September 8th, 2022. Your bond is currently set at $0. You'll need to go before the court, the trial division, in order to get a bond set. Dion McKnight. Mr. McKnight, you're before the court at this time for an initial appearance. You've been charged with the offense of possession of methamphetamine with intent to sell. Your bond is set at $10,000. You're also before the court at this time on, with count 2, trafficking in methamphetamines greater than 200 grams. Your bond in that, as to that count, is set at $250,000.
Your Honor, that was 250. I apologize.
Yes.
Okay, thank you.
Danielle McMillan. Good morning, Ms. McMillan. You're before the court at this time after being charged with the offense of prostitution.
Yes.
It's your third subsequent violation. Your bond is set at $1,000 at this time. Also, does she qualify for appointment? I'm sorry, it says that you do not qualify for court-appointed counsel? Is that right?
No,
That's correct.
Okay.
Okay, all right.
Your Honor, we do apologize. Oh, you said she don't qualify for public defender.
Based on the affidavit she filed, she does not qualify for a public defender at this time.
Can I speak on her behalf as a friend of the court or no?
Yes.
Okay.
I'd like to.
She would like to know if she can be ROR'd, or if not, in the alternative, can you reduce the bond that's already set? She informed me that $500 is more in her reach to be able to afford to be.
I'll grant her a bond of $500.
Okay, so she do 500.
Langwin. Good morning, sir. You're before the court at this time for an initial appearance. You've been charged with the offense of petty theft with 2 prior theft convictions. Your bond is set at $1,000. Thank you.
Your Honor, also include the no return condition?
Yes. Thank you. You're not to return to the scene of the offense, sir. Efren Rosario? All
Refuse, Your Honor.
We will waive his appearance, Your Honor.
right, thank you. He was picked up on a warrant from Orange County, Florida, for failure to appear at a status hearing on May 26, 2022. His bond is revoked and set at 0 at this time. Rami Sahir? Is that you, sir?
Yes, Your Honor.
All right, you're before the court at this time for initial appearance. You've been charged with the offense of possession of cocaine. Your bond's being set at $1,000. It appears that you do not qualify for the appointment of the public defender's office to represent you. Therefore, you'll need to retain private counsel if you wish to be represented by an attorney. You're not to possess any controlled substances without a valid prescription from a physician. Thank you.
And Your Honor, it was found before court that he does have an open case. He's out on pretrial diversion right now in 2022 CF 001650 AO for a possession of cocaine with intent to sell or deliver.
I'm not going to take any actions since the state is involved in a pretrial diversion with him.
And he does have reporting requirements.
He does have what?
Reporting requirements, he just needs to update his address.
Okay, let's see if does he need to do that here, or is he going to do that?
I think he
Do I
has,
need to tell him that, because he just went out the
yeah,
door?
he just needs to report to the sheriffs.
Okay. So I brought you back in because you're reporting requirements, so I want to make sure you understand that once you bond out, you need to report to the sheriff's office.
Okay.
All right, thank you. Craig Hewley? Sir, you're before the court at this time after being picked up on a capias for your failure to appear at an arraignment in case 2021 MM285. Your bond was revoked, and now your bond has been set at a new amount of $5,000. And that's all we have for you. Frank Lipsy?
Be bonded, Your Honor.
Stephen Lachlan?
Don't have that name on the docket, Your Honor.
You bonded?
Do you have their booking number, Your Honor?
Oh, yes, the booking number is, well, the inmate number is 22025393.
They bonded.
Okay, thank you. Gert Beal Serrano? Sir, is
have-
that your name? No? Okay.
Do you have their booking number, Your Honor?
Yes, it is 22025413.
They also bonded.
Thank you. James Varela?
Yes, ma'am.
All right, good morning, sir. You're before the court at this time after being charged with the offense of driving with an expired license for more than 6 months. Your bond is currently set at $500. Thank you. Aaron Bradsfield? Is that you, ma'am? You're before the court at this time after being charged with prostitution. Your bond is set at $500. You're out on bond at the time that you picked up this offense. You're released on your own recognizance. That is revoked at this time. I'm going to set that bond at $250.
Your Honor, I do apologize. I understand you just set bond to $500. She would like to know if she can be ROR'd in regards to count 1.
No, she picked up a charge while she was out on ROR. All
Thank you.
right, thank you. James Brooks?
Be bonded, Your Honor.
Elijah Burford?
Mental health, Your Honor.
Defense will waive, Your Honor.
Right, defendant was charged with the offense of loitering or prowling in case number 2022 MM7291. The bond is set at $250. The defendant is not to return to the scene of the offense. Defendant is also charged in case number 2000. I'm sorry, this is on view. Defendant also has an out-of-county offense for a violation of probation. bond is set at 0. This is an out-of-county affidavit that has been filed with an on-view violation of probation. The bond is set at 0 and will need to be established before the trial court in that county. Carlton Jackson.
Excuse, Your Honor.
Defense will waive, Your Honor.
The defendant is charged with the offense of trespass on property after warning. Bond is set at $500, and the defendant is not to return to the scene of the offense. Catherine LaChance. Ms. LaChance, you're before the court at this time after being charged with the offense of prostitution. Bond is set at $500.
Your Honor, in regards to this case, client would like to know if she can be released RR.
Yes. Court will grant RR. Brandon Melendez.
Behavior, Your Honor.
Defense will waive, Your Honor.
Defendant was charged with the offense of trespass on property after warning. Bond is set at $500. The defendant is not to return to the scene of the offense. Laura Moore. Ms. Moore, you're charged with the offense of prostitution. Your bond is set at $500. At the time that you picked up this offense, you were out on surety bond for the charge of possession of cocaine. That bond was set at $1,000. I'm going to revoke that bond in order that the bond be increased to $1,500.
Your Honor, in regards to this case, we're asking, the case that she's out on bond on, no information has been filed yet, so we're asking the court if you can take no action.
Do you agree with that, State? No info has been filed?
No objection to taking no action since there's a bond set in the new charge.
All right, I'll take no action as to the bond that's previously set.
One moment, Your Honor, she has a question. Your Honor, in regards to count 1, client is asking if that can be reduced to $250.
State?
Your Honor, Ms. Moore appears to have a substance abuse problem, and it's our position that the prostitution bond should stay at $500. She was just convicted for possession of cocaine. Last year, she was out for possession of cocaine on bond when she picked up this charge, and it is our position that for her safety in the community, she needs to be given a bond of $500.
I'm going to order that the bond remain at $500. I'm also going to ask that the minutes reflect that she should be referred to the drug court program. Thank you. Peter Roberts.
Mental health, Your Honor.
Defense will waive, Your Honor.
Defendant is charged with trespass on property after warning. Bond is set at $500. As to that count, as well as count 2, possession of drug paraphernalia, the court set the bond at $100. Defendant is not to return to the scene of the offense. Justin Stewart. Sir, you're before the court at this time after being picked up on an out-of-county warrant. The warrant charges you with armed burglary of an unoccupied structure as to count 1, criminal mischief as to count 2, grand theft of a firearm as to count 3, grand theft as to count 4. Your bond is set pursuant to this warrant at $5,000 as to count 1, and as to counts 2, 3, and 4, your bond is set at $150 each. To request the extradite, at the time that you, well, I don't know the date of the.
Your
I
Honor,
don't know
that,
the date of the offense.
the first appearance detainer was closed, it was entered in error. Due to the offense dates, it shouldn't have been put in.
So do not touch the
Yeah,
previous
the open cases occurred after
Okay.
the offense in Osceola County.
Great, thank you. That was my question. I was like, I don't know when that date was. And so that's all we have for you is to relate to that out-of-county warrant. No. Unless I mixed it up with this one. You want me to ask?
You have to.
Anthony Archer? So you're before the court at this time in case number 2021 CF 9834 for alleged violation of probation. Your bond is set at none in that case. In case number 2022 CF 12658, you've been charged with possession of a controlled substance. Your bond is set at $1,000. And possession of cannabis less than 20 gram, your bond is set at $150 as to that matter.
Yes. For the BOP, you have no bond on the BOP. You can't bond out.
If I didn't call it, he would be back there, right? Do you have Khalil Solomon back there?
Your Honor.
He refused, okay. We took care of that. Did we call that already? Do you recall? We have not called it. Oh,
You haven't called
I
him.
don't think we called him, Your Honor.
okay, thank you. That's what we're trying to figure out up here, so
Yeah.
thank you. Appreciate your help. Okay, so with that, I'll call, I'm gonna go ahead and call Khalil Solomon. He refused. Counsel?
Defense will waive, Your Honor.
All right, Mr. Solomon was picked up on an out-of-county warrant for failure to appear. And this warrant is from Polk County. And bond is set at 0 at this time. Thank you. You're welcome. Anthony Archer, is that you, sir? Nope,
We just saw Archer.
we just saw Archer. Oh, thank you.
Gaines would be next, I think, Your Honor.
Earl Gaines? All right, so you're before the court at this time for an alleged violation of probation. That was pursuant to a warrant that was issued in case number 2015 CF 13603 in the Orange County, Florida. Your bond is set at none at this time. You'll need to go before the trial judge in order to get a bond.
And Mr. Gaines does have reporting requirements.
And so you're also required to report, upon your release, be sure to report to the sheriff's office, once you get a bond. Jerry Foraker?
Mental health, Your Honor.
Defense will waive.
The defendant was charged with the offense of violation of trespass after warning. Bond is set at $250. He's not to return to the scene of the offense. Jaia Wilburn?
Bonded, Your Honor.
That's all I have.
Yeah, and I was gonna give him credit
That's all I have. Court is adjourned.
Thank you.
Yes, Your Honor, in regard to the false name charge, defense and fine PC would ask the court not to. In regard to the false name, the affidavit says that Mr. Royal didn't give a name at all, which is substantially different from giving a false name. The statute only references providing false information and doesn't reference about silent or not providing a name at all. So defense would find that there's no PC and would ask the court to release him ROR.
Thank you. Anything from the state?
Nothing from the state.
All right, thank you. At this time, the court does not find PC as to count 1. Court finds probable cause as to resisting officer without violence, set the bond in that charge, $500.
Your Honor, he qualifies for direct.
I'll grant it pretrial release, yes.
Thank you, Your Honor. Thank you.
RR as to count, no PC was found. The next case is David Felice. So you're before at this time after being charged with the offense of simple battery, which is a first-degree misdemeanor. At this time, I am going to set the bond at $500. You're to have no hostile contact with the victim, who is your wife. You're welcome.
Your Honor, I apologize, Joy Gibson with pretrial release. Would that be with pretrial release?
Yes, that's with pretrial release, because he does qualify for pretrial and bond.
Yes, thank you.
Thank you. Alfredo Gordon. So you're before the court at this time for the charge of giving a false ID to law enforcement. That is a first-degree misdemeanor. At this time, I'm going to release you on pretrial release.
Thank you.
Mitchell Gray. Mr. Gray, you're before the court at this time after being charged with the offense of domestic violence battery by strangulation. At this time, I'm setting your bond at $500. You're to have no hostile, you're to have no hostile contact with the victim in this case. You're also not to consume, you're not to consume any controlled substances. You're to possess no firearms or weapons. Thank you.
Your Honor, would you be taking any action on the case he's out on bond with pretrial release on 22 CF 2835?
I don't have that information.
Your Honor, this affidavit stated that the victim does wish to press charges. Are you ordering no hostile contact or no contact?
No hostile contact. I thought I said no hostile contact.
I wanted to make sure. Okay.
Is that what I said?
Hostile contact.
Okay.
You're taking action on that case?
Ma'am, before I answer that, I thought I said no hostile contact. Okay, I did. Madam Clerk confirmed that. So I said no hostile contact in the matter. And in regards to that case, I don't have any other case before me. Is there any other information that I have?
Yes, ma'am, it's notated on the initial appearance sheet that we sent over this morning, but I can give you the case number if you don't have it.
We don't have any other sheet, ma'am. That's what I'm saying. I don't have another sheet.
Defense requested no action is taken.
Again, I don't have the information, so I'm not going to take any action unless Madam Clerk has some additional information. We don't have that, ma'am. All right, Jamal Harris.
Mr. Harris is in the cage, Your Honor. A moment, please.
Your Honor, if I may ask the court, when we address the cases that are out on bond or would you need the bonding information sent over as well with the information sheet or no? Are we?
Yes, I need.
I'm sorry?
Yes, I would need the information in regards to the case and the charges that have been filed, as well as what the bond amount are.
Okay, thank you.
You're welcome. You can keep these, these are the ones that I know. You can keep these. All right. May I ask who is the young lady who's speaking with me in regards to the bond?
For a pretrial release, that's Joy Gibson.
Is that your name, ma'am?
Yes, ma'am.
Okay, good morning. I can't see you, so I just wanted to be able to address you. So I apologize. I am informed that Osceola does it different than Orange County. So I did not realize that it was on the pretrial release form that was sent over. So I was mistaken that it is provided on that form, and I did not recognize that because I looked at the form for the purposes of seeing if the defendant qualified for pretrial release. So now that I'm aware of that information that you're asking me to address, it indicates that he was out on, and this is as to Mr. Mitchell Gray, that he was out on bond with pretrial release in Osceola County case 22CF 2835. And that was for the commission of domestic battery by strangulation. So at this time, I will revoke that pretrial release in light of the fact that he is before the court again for the same type of offense, in order that his bond in that case be set at $1,000. Thank you. Just a moment. All right, thank you. This is Jamal Harris. Sir, you've been charged with the offense of false ID to a law enforcement officer, first-degree misdemeanor, as well as possession of a controlled substance, which is a second-degree felony. As to count one, the bond will be set at $100. As to count two, your bond is set at $1,000. You're not to possess any controlled substances. Thank you. Charles Carnes or Cairns. Morning, sir. You were picked up on an out-of-county warrant from Polk County, and there was a probable cause finding for this warrant, charging with you with the misdemeanor offense of shooting into a building. And there's a no bond order as to that charge. There was also a probable cause finding that you were tampering with physical evidence. The bond is to that count is set at $1,000. Thank you. Odaria Perry. Ms. Perry, you're before the court at this time for 2 counts of battery on a law enforcement officer, firefighter, or intake officer. As to count 1, well, actually, I'm going to release you on pretrial release as to both of these counts since you qualify. You're not to have any hostile contact with law enforcement, firefighters, or any type of intake officer. Thank you. Charles Sawyer. I'm fine, sir. How are you? I'm doing good. Good. Thank you for asking. Mr. Sawyer, you're before the court at this time for the offense of possession of weapon or ammunition by a convicted felon, which is a second-degree felony, as well as count 2, resisting arrest without violence, a first-degree misdemeanor. As it relates to count 1, I'm going to set your bond at $2,000 plus pretrial release. As to count 2, your bond will be set at pretrial release only.
I can't afford the first one, Your Honor. Is there, can I?
Your Honor,
I really can't.
Mr. Sawyer is obviously reporting that he cannot afford $2,000. Would the court consider lowering it to perhaps $1,000?
I can't afford that neither. You could do preach.
I already lowered it from the bond amount that's in the schedule. It should be $4,000. I lowered it to $2,000, so I'm going to leave it at $2,000. He's a convicted felon and shall not be possessing any firearms or ammunition. I gave him the benefit of giving him a reduction already. Thank you. Bonnie Smith. Ms. Smith, you're before the court at this time after being charged with the offense of simple battery. I'm going to order that you may be released on bond for $500 with pretrial release. You are to have no hostile contact with the victim in this case. Thank you. Olivia Wysong. Good morning. All right, good morning, Ms. Wysong. You're before the court at this time for the charge of simple battery, which is a first-degree misdemeanor. At this time, I'm going to set your bond at $500. You're to have no contact whatsoever with the victim in the case. You're not to possess any firearms or weapons at this time. Thank you. Trenton Watkins.
Good morning.
Good morning, sir. You're before the court at this time after being picked up on a warrant after probable cause finding that you committed the offense of grand theft motor vehicle. Your bond is set at $2,500 at this time. The warrant is from Orange County, Florida. Thank you. Carla Smith.
Your Honor, Ms. Smith is still detoxing.
Counsel, if you want to come forward and make your appearance as well.
May I proceed?
I just need your name and who's with you.
King Kamara on behalf of the victim, Stenka Natalie Carazana.
Okay. Before we hear from you, let me advise Mr. Sabino of what's going on. Sir, you're here today pursuant to a warrant, pursuant to a violation of your domestic injunction. I have reviewed the charging affidavit, and I do find that there is probable cause for the charges. Before I set any conditions of release, counsel, I'd like to hear from you and your client, and we'll put her under oath if you would like.
Judge, we would like the bond to remain at zero. My client is concerned that Mr. Sabino is a threat to her. There's been numerous violations. I haven't seen the booking report yet, but Judge Netcher entered this injunction on September 13th of 2022 after a hearing, and Mr. Sabino we believe, has violated the injunction in numerous ways and needs to stay in jail to protect Ms. Carazana. If you want to hear any additional from her, we can place her under oath and she can address the court.
Before you
She's concerned about Mr. Sabino being out.
Before you do, let me correct something. I am appointing the Office of the Public Defender to represent Mr. Sabino. You represent the victim, not the defendant. So Mr. Dorsey, what's your position on counsel's argument?
My position is that.
Closer to the mic, please.
My position is that he should be given bond. This is a non-violent offense. He made contact with his son.
All right, and what's the state's position?
Your Honor, if Your Honor hasn't already done so, the state would request that his bond be revoked on what he's currently out on PTR for, 2022 MM 2014. It's also the state's position that if that bond be set high in this case, these are two court orders that the defendant has flagrantly disregarded. And the state would also ask that Your Honor enter in an additional no contact order with the victim, seeing as through her counsel, she has expressed that she is in fear of the defendant and does not wish to have contact with him.
Okay, thank you. Ma'am, would you raise your right hand to be sworn? Do you swear and affirm the testimony you're going to provide today is the truth, the whole truth, and nothing but the truth, so help you God? All right, state your name, please, for the record.
Natalie Carazana.
Are you afraid of Mr. Sabino?
I am.
How long have you had an injunction of some type in place against him?
This would be the second one since September 13.
Okay, and in this case, he violated the injunction by approaching your children at school, is that correct?
That is correct.
And your injunction includes your children in the scope of it, correct?
That is
Okay.
correct.
And Judge, if I could just add, we believe that there was other contacts that were made by Mr. Sabino to relatives of Ms. Carazana, and that's part of, I'm going to be filing a verified motion for contempt in front of Judge Netcher, dealing with that case. But those contacts, I don't, probably are not in the police report because they were made to a relative out of state. And I also do not know, because I haven't seen the police report, but there was, Ms. Carazana's indicated that what we believe is Mr. Sabino's truck was in her neighborhood, parked outside of a neighbor's house.
Okay. I don't know that I can consider that at this time because it's not a part of the uniform charging affidavit. As indicated previously, I do find probable cause for the charge based upon the allegations set forth in the uniform charging affidavit. State, what is your position on a no bond argument?
Your Honor, the state is not seeking to file any pretrial detention motion in this case at this time.
Bond is set at $50,000 with the additional condition that you're not to have any contact with the victim or her children, that you are to comply with the existing domestic injunction orders, that I also find that this new charge constitutes an on-view violation of the conditions of your release in 2022 MM 2014. Accordingly, I'm revoking those conditions of release and ordering that you're to be held on a no bond status until such time as you're brought before the presiding judge in that case. I'm also, does the existing domestic injunction include a distance radius around it?
500 feet.
Okay.
From her residence as well as from her employment, which is in the injunction.
I'm also including the school where your children attend as part of that. You may be seated. Thank you, folks.
Thank you. You have a good day.
Deputy, we had more folks come in. I'm going to need the names of the cases that they're on.
We have Mr.
Oh, they were all together, disregard.
Yes, Your Honor.
Sorry.
This young lady here is just viewing.
Okay. Gonna call up. Let's put Mr. Thompson on.
Your Honor, what were the cases I got?
Jonathan Carrillo. Jonathan Carrillo's next.
And he also filed an NOA for Ms. Almala Alina White.
Thank you.
It is a new criminal felony case.
I need him on the phone.
Mr. Thompson?
Yes, ma'am.
Can you not teleconference him into the system?
I've tried to do that before. In some courtrooms, it doesn't work. Like in Judge Egan's, it didn't work, and Judge Carson's, it did. I can try.
Give it a try. Because they're not going to be able to hear him.
One moment. I'm gonna call you right back, okay? No problem. Try it, Judge.
There's nothing blinking. You have to transfer it to the phone number in the courtroom so I can hit teleconference.
This is how I was instructed to do it, and this is how I did it before. I could transfer it to your phone.
Let's do that.
May I have your extension?
22580. I did not.
Hello, Mr. Thompson? One moment. Mr. Thompson? Doesn't appear to be working, Judge. Give me one moment, I'm so sorry. I am trying to transfer to the judge. Still nothing?
No. Are you putting them on hold first?
Yeah, I've tried several different ways. I've never had problems in several courtrooms, so.
You have had problems, you said?
I've transferred it to Judge Carson directly
That's
through
what I
the
would
system,
like
where
to
it
do.
played in the courtroom. And then I've also had to use the speaker because some courtrooms don't allow the transfer.
I transfer all the time in here when I'm in trial, so.
Right now I have him on hold. Right? Transfer. 22580.
Correct.
I tried to put him on hold, transfer 22580, transfer again.
All right, just put them on speaker then.
Attorney Thompson? Hello? Can you hear me?
Yes, ma'am. I can hear you. Can you hear me?
Yes, sir.
Ma'am, how you doing?
All right, I've just called the case. This is Judge Schreiber. Good afternoon. I've just called the case of Jonathan Carrillo. Counsel, would you state your appearance again, please?
Attorney Harold Thompson on behalf of Mr. Jonathan Carrillo. How you doing, Your Honor?
Doing okay. Let me ask Mr. Dorsey, can you hear him over where you are?
Yes, I can hear him.
Okay, very good. We've kind of had a bootstrap how this works today, so as long as everybody can hear, I think we're okay. Mr. Carrillo, you are charged pursuant to a warrant out of Orange County, Florida, with the following, looks like you were picked up with an Orange County, Florida warrant for the crimes of organized fraud, money laundering in an amount greater than $100,000, and conspiracy to traffic controlled substances. Counsel, did you want to be heard? Because I'm going to recite what the conditions of the bond were for Orange County. And those
Yes, Your Honor.
those
Yes, Your Honor. I want
conditions
to be
were,
heard briefly. I'm not sure why he has a hold on him because the other individuals who were arrested all had bond set. It was possibly because he was previously placed on probation within the last month, a month and a half. But I believe this investigation in regards to this new law offense predates him being placed on probation. So I would ask if we could have a reasonable bond set in this case, Your Honor.
Counsel, I am going to decline that request for now. I'm going to go with what was originally in the warrant out of Orange County, which said a no bond status on all 3 counts, order that he surrender his passport, have no contact with the co-defendant or the victims. I would prefer that you handle this, given the nature of the charges and the conditions in the bond, in Orange County before the assigned judge who has access to the full information and record.
Your Honor, if I just may briefly state, I don't believe he's charged with a life felony or a capital felony, so he should be entitled to a bond at this point.
Well, I'm not doing a bond hearing today. I'm simply advising him that he's going to be transported up to Orange County for pursuant to a warrant that was issued out of Orange County.
Got you. Okay.
All right.
Thank you, Your Honor.
All right, don't go away. You may be seated, sir.
Would you like for him to surrender passport to Orange County Court?
Yes, he's to surrender passport to Orange County, not pursuant to the Orange County warrant. Counsel, I understand you filed a notice of appearance for Amala White, so let me call her up next.
Yes, Your Honor. And I recently read the probable cause affidavit. I do have some issues with the initial detention. I don't believe the officer has sufficient probable cause to detain her to begin with. But however, this is a constructive possession case, and I do believe that a bond is set in all counts, but I believe the $100,000 bond is excessive in light of the fact that she has no prior criminal history, never been in trouble before. She's a diabetic. That would explain the needles that she had in her bag. That's for her own self-medication. And I would ask if we can have that bond reduced from $100,000 that's to count 1 to a more reasonable bond that's more attainable.
Well, let me let her know what she's charged with. Ma'am, you're charged with trafficking in oxycodone in an amount greater than 7 grams, possession of marijuana over 20 grams, and delivery of synthetic cannabinoids. Let me hear from the state attorney. Counsel?
Yes, Your Honor. The state would argue that there's certainly PC. Constructive possession isn't even a defense at trial. You can still be found guilty as charged, even based off of constructive possession. As for reasonable suspicion, I think it's quite clear within the 4 corners of the arrest affidavit that there was reasonable suspicion. Additionally, the state would argue that probable cause is a lower standard. It's within the 4 corners of the affidavit, given the information to the officer at the time that something was likely to occur. And in the event that Your Honor is not persuaded by the state, we would ask for an additional 24-hour reset.
What's your position with the request to lower the bond on count 1?
The state's not taking any position on the bond amount. We would leave it in Your Honor's discretion.
Okay. And counsel, I have reviewed the arrest affidavit or the arrest warrant. I do find there's probable cause for all of the charges, but I am inclined to reduce the bond on count 1. I'm going to reduce it from 100,000 to 50,000. That's half the bond. If you want to go lower than that, go ahead and file a motion for a bond hearing before the assigned judge. And I'm going to set it at $2,500 on count 2 and $2,500 on count 3. Is the state asking for any other conditions?
No weapons or firearms.
Okay. And do not possess weapons or firearms.
Thank you, Your Honor.
All right. Thank you, sir. Have a good day.
Thank you so much. Have a great weekend.
Yes. Guillermo Ortiz Pabon.
Your Honor, you refuse to come to court.
I'm going to find his refusal to be a waiver of his appearance, and we're going to proceed, since I've appointed the Office of the Public Defender to represent him. He's here pursuant to an out-of-county warrant issued out of Orange County. Underlying charge is a violation of probation in connection with an ag assault with a deadly weapon. Bond is set at $0, no bond. He's to be held pending transport. Orlando Eli Agosto.
Afternoon, Judge.
Good afternoon, sir. You're here pursuant to a bench warrant that was issued by Judge Epperson for your failure to appear for your arraignment. Judge Epperson did give you a bond. That bond is $1,000. All right, sir?
But in the paperwork they gave me, I think they made a mistake because it says failed to file, received a bad tax violation. And I've been trying to bond out since the 24th, and I haven't been able to because of that.
Well, it's actually failure to appear. That was crossed out in my paperwork, and it's the underlying charge is petty theft. So you failed to appear. That's why you're in jail for your arraignment in connection with the petty theft count. And you do have a bond, so you should be able to bond out. All right? Embark Lagnewi. You are here for pursuant to a bench warrant issued by Judge Sanders Morency for failing to appear for your arraignment. Judge Sanders Morency set your bond at $5,000 until such time as you're brought before her. Anthony McCray, Jr.
Good afternoon, Your Honor.
Good afternoon. You're here pursuant to a bench warrant issued by Judge Epperson, failure to appear for your arraignment, and your bond was set by Judge Epperson at $1,000. James Rushbrook.
Real quick, 2 seconds.
Okay, sir, you are here based upon a violation of your probation. Underlying charges were fleeing and eluding and DUI misdemeanor. It is alleged that you failed to report, changed your residence without notification, and picked up a new law violation in Alabama. Bond is set at $0, no bond until such time as you're brought before the presiding judge.
BOP arraignment November 7th, 8:45 a.m., quorum 5F.
You're muted, sir. I think you've been muted down there, so have a seat. Bernie Velez.
Good afternoon, Your Honor.
Good afternoon. You are charged pursuant to a warrant for violation of your probation or community control. Looks like on more than one occasion, or at least one occasion, you failed to remain confined to your approved residence. Your bond was set at 0, no bond by Judge Nick Swacker.
BOP arraignment, November 8th, 9 a.m., courtroom 5A.
Alexis Carrasco.
Good afternoon, Your Honor.
Good afternoon. Sir, you have 3 cases today. Case number 1, fleeing and eluding a law enforcement officer with lights and screen activated. I've reviewed the charging affidavit. I do find probable cause for the charge. Bond in that case is set at $5,000. Case number 2, carrying a concealed firearm. Again, I've reviewed the charging affidavit. I find probable cause for the charges. Bond is set at $2,500 on that count. Case number 3, resisting arrest without violence. I do find probable cause for that as well. Bond is set at $500. You are also out on 22 CF 7233 in Orange County. Looks like pretrial diversion, county diversion.
Yes, ma'am.
Well, I'm going to revoke the conditions of your release in that and order you to be held no bond until such time as you're brought before the presiding judge. And they can figure out what to do with it, all right? With regard to, I am going to add one more condition, and that is on the new charge, carrying a concealed firearm as a condition of your bond, you are also not to possess any firearms as a condition of your release. Peter Gilboy.
Your Honor, I do have probable cause argument in this case.
All right, Mr. Gilboy, you're charged with failing to register. Counsel, go ahead. Hold on one second. Let your lawyer talk for you.
Your Honor, I reviewed the arrest affidavit, and I saw no evidence in it that Mr. Gilboy was in the county for over 48 hours. It seems to just be a conclusion that he was there for over 48 hours.
I agree. What does the state say?
Your Honor, the state does agree, however, we would ask for a 24-hour reset.
I do not find there's probable cause for the charge. Case is reset for, the state has 24 hours to file an amended charging affidavit setting forth probable cause. Case will be reset for tomorrow. Giovanni Gonzalez. Sir, you're charged with driving while license suspended or revoked or equivalent status. I've reviewed the charging affidavit. I find probable cause for the charge. Bond is set at $500. You're ordered not to drive without a driver's license, although I'm not sure that's going to work. With regard to 22 CT 883, I'm going to take no action in connection with revoking your conditions of release. Jamila Thompson. You are charged with petty theft in an amount greater than $100 but less than $750. I've reviewed the charging affidavit. I do find probable cause for the charge. Bond is set at $500 with the additional requirement that you are not to return to the Walmart located at 2855 North Old Lake Wilson Road in Kissimmee.
Your Honor, is there any way we could lower the bond in this case?
I'll drop it to $250.
Thank you, Your Honor.
James Rowland. Sir, you're here on a couple of charges, a couple of cases. Case number 1, possession of cocaine and possession and/or use of drug paraphernalia. I find probable cause for the charges. Bond is set at $2,500 on count 1 and $250 on count 2. You're also charged with driving while license suspended or revoked or equivalent status. Third subsequent violation. Bond is set at $2,500. And last but not least, grand theft auto and criminal mischief in the amount of $200 or less. Bond is set at $2,500 on count 1 and $250 on count 2. In case I wasn't clear, I do find probable cause for all charges. Enrique Santos. Mr. Santos, you are charged with driving under the influence of alcohol or drugs and refusing to submit to a DUI test with an automatic license suspension. I've reviewed the DUI charging affidavit. I find probable cause for the charge. Bond is set at $500 on each count. Well, hold on a second. State, does he qualify for direct PTR pursuant to the administrative order? Actually, let me ask PTR. Does he qualify for direct PTR pursuant to the administrative order?
Yes, ma'am.
Then that's what I'll give him. Direct PTR pursuant to the administrative order. As a condition of your release, you are not to drink and drive. Isaias Santana Rivera. Sir, you're charged with the following: committing a domestic battery by strangulation, domestic in nature, and battery, unlawful touching or striking, domestic in nature. PTR, still no contact with the alleged victim in this case?
No, ma'am.
Then bond is set at $2,000 on count 1, $1,000 on count 2. You're ordered to have no contact with the alleged victim, maintain separate residences. If need be, you may return on a one-time basis in the presence of law enforcement to gather your personal possessions. And do not possess any weapons or firearms as a condition of your release. You may be seated. Carla Smith?
Your Honor, she's not here right now.
Is there a reason? Is she medical? Did she refuse?
Medical.
She's in medical? Then this will be reset for tomorrow.
Thank you, Your Honor.
Let me change that. This will be reset for first available. All right? Chanel Mitchell. Ms. Mitchell, you're charged with one count of battery, simple touching or striking domestic in nature. I've reviewed the charging affidavit. I do find there is probable cause for the charge. Before I set the conditions of your release, sir, would you give me your name?
My name is Daniel.
Nice and loud.
My name is Daniel
Daniel, can I have a last name, please?
Mendez Cruz.
Okay. And you're the alleged victim in this case?
Yes, ma'am.
Raise your right hand. Do you swear and affirm the testimony you're going to provide is the truth, the whole truth, and nothing but the truth? So help you God. I don't want to hear about what happened this time because anything you say can be used against her in a future court proceeding. My concerns have to do with your level of fear or concern about contact with Ms. Mitchell. My first question is, are you afraid of Ms. Mitchell?
No, ma'am.
Do you want contact with her?
Yes, ma'am.
If she were to become violent in the future, what would you do?
Call you guys.
By you guys, would you have any hesitancy about calling 911?
Yes, ma'am.
Okay. So you would call 911? Okay.
I don't fear her or nothing.
I-
Just, all I'm trying to do is just get 50-50 with my son. Be able to see my son.
All right. You live together?
No, ma'am.
Ma'am, bond is set for you at $500. You're to have no hostile contact with the alleged victim in this case. You'll get paperwork that describes what constitutes hostile contact, and it includes indirect hostile contact, such as screaming on a telephone or sending nasty grams via Instagram or text message. So you'll get an explanation of what constitutes hostile contact. You're to possess no weapons or firearms as a condition of your release. And I think that's it. You may be seated. Thank you, sir. John Wolf. Mr. Wolf, you're charged with one count of battery, unlawful touching or striking domestic in nature. I find probable cause for the charge. You're also charged with violation of a domestic injunction. And I find probable cause for that charge. PTR, it is unclear to the court whether the victim in these cases is the same victim in the 22 CF 1698 battery case.
It's the same victim.
It is, okay, it wasn't circled, it said, okay. All right, thank you. All right, bond is set at $1,000 on the battery count, along with the condition that you are to have no contact with the alleged victim. You are not to go within 500 feet of her residence. You are not to possess any weapons or firearms. in connection with the violation of a domestic injunction. State, Mr. Dorsey, my understanding is these folks do not live together currently because of the existence of the domestic injunction. Is that accurate?
Yes, from what I've seen in the arrest affidavit, it says he lives in a shed.
Okay.
She lives somewhere else.
Okay. On the domestic injunction violation, bond is set at $2,000. Again, you're to have no contact with the alleged victim. These charges violate the conditions of your release in 22 CF 1698, which is another battery domestic by strangulation case. I'm going to revoke your ROR in that case, hold you on a no bond status until such time as you're brought before the presiding judge. State, did I miss anything on that one?
No, Your Honor.
Okay. Counsel,
And that's the same conditions as the previous.
yes, same conditions as the previous case, correct. Counsel,
Your Honor, we actually do have the interpreter on the line. That's the last one.
hold on one second. Is there any, would you look around and ask if there's anybody in the room that hasn't been called other than Pierre Ledger?
There is Riley Jamal.
Can't hear.
Oh, he bonded? Okay, then, no, this is the last one, the Creole.
Okay, Pierre Ledger. Go ahead and get him. Yeah.
Madam Interpreter?
Good afternoon. Good afternoon. Have you been sworn? Okay, let me talk to the interpreter. I need your name, your identification number, and whether or not you've been sworn.
I'm sorry?
Can you not hear me?
Not very well, no. It sounds very echoey.
Then I need you to put the phone up here. Because the speakers are not carrying over to her. Put it here if it'll go. Will it reach here? All right, can you hear me better now?
Yes, much. Thank you.
All right, could I have your full name, please? Your, the number that you always provide and whether or not you've been sworn.
My name is Isabel DeRoster, Creole interpreter. I have been sworn in.
Okay, thank you. I've just called Pierre Ledger, case number 22 CF 3070.
Pierre Léger?
Sir, you're charged with one count of battery, unlawful touching, or striking domestic in nature.
Monsieur, ou accusé de un chef d'accusation que ou témoigner ou bien frapper un moun contre la loi.
Hold on, ma'am. Yes, sir?
We would like to waive the reading of the charges, please.
Okay. And, sir, your attorney has waived the reading of the additional charge.
L'avocat dit que nous pas besoin lire l'autre accusation yo.
I have reviewed the charging affidavit, and I do find probable cause for the charges.
Moi lis excuse me. Moi lis attestation et moi joigne que gagne assez cause probable pour accusation yo.
Bond is set at $1,000 on count 1 and $2,500 on count 2.
Première accusation, bonne là pour $1,000. What was count 2, Your Honor? I'm sorry?
$2,500 on count 2.
Et $2,500 pour deuxième chef d'accusation.
You're ordered to have no contact with the alleged victims in this case.
Il y a un ordre pour ne pas avoir aucune qualité de contact avec victime dans le cas.
You are ordered not to maintain separate residences and do not return to the location where this occurred.
Il y a un ordre pour être dans un autre cas que victime et pour pas retourner côté bagage ça été fait.
You may return on a one-time basis in the presence of law enforcement to gather your personal possessions.
Ou capable retourner une grande fois ensemble avec la police pour aller prendre tout affaire qui n'a qu'à là.
You are to possess no weapons or firearms.
Ou pas capable de aucune arme ou bien aucune arme à feu.
State, are there any other conditions you're seeking?
Non de l'État, est-ce qu'il y a d'autres conditions que l'a cherché?
No, Your Honor.
Il dit non.
Sir, did you understand everything the Creole interpreter said to you?
Monsieur, est-ce que vous te comprenez toute bagaille que l'interprète créole te dit?
I heard him say "we," so.
I did, the interpreter did not get
Okay.
that.
It
at
came
all.
through on the courtroom. All right, you may be seated, sir.
Machita, monsieur.
Thank you, Madam Interpreter.
Oh, you're very welcome, Judge. Have a good afternoon. Bye-bye.
I think our job here is through, counsel. Everybody's been addressed?
Yes, that was it,
All right, thank you for your help.
Have a great weekend, Your Honor.
You too.
You're welcome.